So thank you and good afternoon. I think we will get started. Thank you for joining this webinar in relation to non-court dispute resolution and the new rules that will come into effect entirely by the 29th of April of this year. We're going to run this webinar fairly tightly to time. We will continue until 10 to 2, and then there will be an opportunity for questions and answers. If you want to pose a question, could you please use the Q&A function on your screen. We thought we'd begin by introducing ourselves. I'm now working with a psychologist to do NCDR, and I'm working through a set of chambers, 3PB, to do the round of arbitration and private FPR work and that sort of thing. So that's me done. But I wonder, Nick, could you introduce yourself, please?
Thank you, Stephen. I'm barrister and joint head of chambers at 29 Bedford Row in London, door tenant St Ives Chambers in Birmingham, Deputy High Court Judge, Family Division, and a recorder of Family Court.
And Martin, please.
Yeah, similarly, I am a barrister based at 36 Family in London. I'm head of the children team there. I am a recorder to the Family Court and a Deputy High Court Judge too. Thank you.
And Karen, please.
Thank you, Stephen. I'm a consultant at Moore Barlow Solicitors. I now practice entirely in the outer court space as a mediator and parenting coordinator. I'm a member of Resolutions DR Committee, the Family Solutions Group, author of the Sor Initiative and co-author of the Family Solutions Initiative.
Well, thank you. And Reese, please.
Good afternoon, everyone. I'm a barrister at 36 Family. I'm a member of the Family Procedure Rule Committee, and I was on the working party that has developed the new rules which are coming in. I'm also a recorder of the Family Court.
Thank you. And Graham, please.
Yes, hello. I'm a partner and head of family at BBS Law. I am a solicitor member of the Family Procedure Rule Committee. Thank you.
Thank you. So I wonder, Hannah, whether you might now please show some slides that we've prepared. Well, one of the points that we want to begin with is that the court is, as everyone will know, really struggling with the amount of work that comes into it. And we thought it might be helpful to show you the state of the statistics. So financial remedy, this is as of July to September 2023 in comparison with the same period the year before. Applications, financial remedy up by 15%. Compare the figures between 2014 and the period we're looking at, an additional 2,265. Private law, although applications are down, the increase since 2014, you'll see at the bottom, 2014, 9,291, now 13,420. Could we look at the next slide, please? Domestic abuse and domestic violence applications, a slight increase, but the numbers have doubled very nearly since 2011. Adoption and orders, adoption applications and orders up by 3%. Dolls cases have gone through the roof, 1,248% increase for all sorts of reasons. If you could show the next slide, please, thank you. Public law, in the period we're looking at, increased by 4%. It did go down for a while. Average duration 46 weeks nationally. The number of children in care at a record level, nearly 84,000 in March 2023. That's one in every 143 children. And where's that going to go? So just the last two slides now. So what did the president say before the pandemic? He described it as being like running flat out up a down escalator. Could we now look at what the president of the Law Society said on the next slide, please? And you'll see the third bullet point. The president in 2022 was saying that the estimate was that we would return to pre-pandemic levels, the level just described by the president of the Family Division, in about 3 years. That's 2025. So if that's right, we're going to get back to the level described in the escalator analysis next by 2025. That's the pressure on the courts, and that is why I would suggest that this topic of non-court dispute resolution has to work now. There must be a way of relieving the pressure on the courts and a better way of doing things. So what we're going to do now, thank you, with that introduction, is Karen, you were involved with the Sor Initiative, and I wonder whether you are involved in it, and I wonder whether you could please tell everybody a bit about that. Thank you.
Thank you, Stephen. It seemed to me as a practitioner working exclusively in the out-of-court space that too many cases were remaining in the court process when there was a sophisticated, increasingly sophisticated array of processes away from the court. It took my mind back to part 3, which I felt was probably largely gathering dust on a shelf. And so I created the Sor Initiative effectively to try and breathe life into part 3, which I think was largely being honoured in the breach. I proposed a part 3 protocol and regulated part 3 obligations so that the parties, their lawyers and the court would put part 3 at all times. And I'll put into the link that the chat, the link to the Sor Initiative, which then with Reese and Martin's assistance became the Family Solutions Initiative. Mr. Justice Cobb was keen to hear more, and I was invited to become a member of the Family Solutions group, and the proposal is also one of the recommendations of that group. So what did it say? Well, effectively, it was about harnessing the skills of family law professionals, but using those skills away from the court where it's safe and appropriate to do so. Essentially establishing a chain of open part 3 correspondence where lawyers or litigants in person would invite the other person to attend NCDR, setting out the rationale, which process was being proposed, how the costs would be met, etc., and the court to have visibility in respect of that open chain of correspondence, both in respect of case management, the conduct of the matter generally, and costs.
So thank you. It's pretty groundbreaking by the sound of it.
Well, I think it was, and certainly practitioners said, I think you could be onto something here. What I'd started to hear was that in London and Surrey, which is where I'm based, practitioners had started to change the correspondence and the way that they engaged the other person, so that effectively there could be seen a proper and genuine attempt in open correspondence to consider NCDR. And what I'd said to practitioners then, and I say now, and certainly in the light of these new rules, is that practitioners will need to make themselves aware of exactly what processes are available to them and where, particularly their local processes. They will need to evidence to their clients that they have considered NCDR not just at the beginning of a case, but that it runs through the case like lettering through a stick of rock, and that they must show that they have invited the other person, or at least if they're on the receipt of an invitation, a proper rationale as to why they want to engage, and certainly when they feel it's inappropriate to do so.
Change of culture. It sounds as though it was very successful, and we owe you a lot for doing it. Thank you. Martin, what are the problems in cases concerning children, please?
Well, Stephen, you will know from a previous incarnation perhaps what it was like. We had developed a system in which we placed an awful lot of reliance on courts to solve issues which were essentially relating to the basic use of parental responsibility, and you brought that to our attention in your Re-B case, which I know all of us will be familiar with. That was fine in some ways in a system which had the resources and the time to allow courts to be to descend to that level of focus. But as we know from the slides which you helpfully provided at the beginning, the courts are now straining under the weight of a huge number of applications. Legal aid was removed for representation for many of those who were engaged in that previous system. And as you now know, less than 20% of all cases involve people who are represented on both sides. So we have the added issue of non-lawyers finding themselves in an alien process where their expectation is that courts will determine those issues for them. And so all of that together combines to create such a burdensome problem for the family court that it means those other cases which otherwise should be, frankly, taking priority are falling back in line as a result of that. And fundamentally, more importantly, the delays caused within that process are resulting in decisions not being made for children. And as we know, delay, as enshrined in law, is inimical to a child's best interest. So we find ourselves in a very, very difficult set of circumstances at the moment. And I'm very grateful to Karen for allowing me to play a role in assisting with the Family Solutions Initiative, because it allowed us to get out there to practitioners the opportunity to consider the use of Part 3 and whether NCDR could be not necessarily mandatory, but certainly something which people would consider prior to, and indeed once applications have been made during the court process, as an alternative means of, or as a result of resolving those disputes, which frankly, they should be able to do so in any event. So it felt like an opportunity which needed to be grasped.
Yeah. Well, thank you. And I mean, it wasn't just that the courts were are becoming swamped. It's also that costs in some instances went totally out of control. And the case that really did it for me and caused me to change career was one where the legal costs were over £1 million in relation to the quantum of contact. I just don't see how that could possibly be allowed. But thank you, Martin. And Rhys, I wonder if I could bring you in, please, to tell us about the pressures that there have been, or the pressure that there's been for change and what people have said. And I think we may touch on something that Nick Allen has said in one particular.
Yes, well, it's been a long runway for these rule changes. And it was, in fact, Mr. Justice Mostyn who was calling for them as far back as 2014. So people complain that the Family Procedure Rule Committee never get anything done. Well, they do. It just sometimes takes a little while. And in the case of Man and Man, practitioners will recall that, in fact, it was about there was an agreement to mediate, and could that be enforced? But Mr. Justice Mostyn took the opportunity in that case to highlight the fact that the rules as cast then and as cast up until the 29th of April meant that unless there was an agreement for the parties to engage in non-court dispute resolution, and the court didn't have the power to adjourn beyond them getting information about non-court dispute resolution. And so he called for the Family Procedure Rule Committee to change the rules to provide that the court could adjourn even if the parties don't expressly agree to attend non-court dispute resolution at that point, for the purposes of them having to attend non-court dispute resolution. It comes very close to mandation, but it's not quite mandation. And then it's also right to mention Nick's case of WL and HL, which really is a masterclass in how I would suggest a template for how judges might deal with the interrelationship between Part 3 and the dispute they have between them. This was a relatively minor issue about nursery fees and how that was going to be dealt with going forwards, wholly disproportionate to be before the court. And so Recorder Allen was providing adjournments for the parties to mediate and then to check back in with him. And they resolved most of it, and there was a very tiny bit of drafting and finishing off that was required at the end. But I would really commend that case as required reading for how Part 3 can be used effectively. But Recorder Allen in that case also took the opportunity to remind everybody that Mr. Justice Mostyn had called a long time ago. I think that case is 2021, and reminded everybody that there'd been a call for a change to the rules in 2014, and we were still waiting.
Yeah, and if I may say, the nice thing about WL and HL is that it's a fairly short judgment. It's really easy to absorb. So we owe you one, Recorder Alan KC.
Can I also very briefly mention, in case people find it hard to find on LexisNexis, that it's in the family court reports, and it's in the family court reports 2021 to family court reports 394.
Great, thank you. So Nick, can we bring you in with that accolade going ahead of you? We're going to hear a tale about Japanese hogweed, I think, and the troubles that the council had in Merthyr Tydfil in relation to it when Mr. Churchill took them to court. Could you help us with that, please?
I can. I think the actual address of where Mr. Churchill lives, I'm going to leave to those who are the Welsh speakers or the closest to being Welsh speakers on the call. I'm not even going to try and pronounce where in Merthyr Mr. Churchill lived. But just before we get to Mr. Churchill, I think it's often the case that where the civil courts lead, the family court follows, and therefore the direction of travel in the civil courts has been interesting. The Court of Appeal had previously held that, pursuant to CPR 3.12M, which there isn't a direct parallel in the FPR, but it's pretty close. But the Court of Appeal had previously held that, pursuant to that rule, the consent of the parties was not necessary for a case to be referred to early neutral evaluation. That was the Court of Appeal in Lomax and Lomax, which is 2019 EWCA Civ 1467. And interestingly, that's actually an appeal, allowing an appeal for Mrs. Justice Roberts. And Lomax at first instance is actually in the FLR at 2021 FLR 30. So the first instance is fully reported, the Court of Appeal isn't. So that's where the consent wasn't needed to refer. That was then followed by the report of the Civil Justice Council in June 2021, their report, Compulsory ADR, and they effectively said that any form of compulsory non-court dispute resolution, which is, quote, not disproportionately onerous and does not foreclose the party's effective access to the court, close quotes, is lawful. So we sort of knew where we were heading in the civil context. So when Mr. Churchill sued the local council for allowing Japanese knotweed to encroach onto his property and causing a reduction in the property value and loss of enjoyment. And the council said, well, hang on, you need to use our internal corporate complaints procedure first. And if you issue proceedings without having dealt with our internal procedure, we'll apply for a stay and costs. Mr. Churchill's solicitors didn't take that lying down. They issued proceedings against the local authority. The council issued their application for the stay. Deputy District Judge Kempton Rees, he dismissed the stay application. He said that he had to follow the well-known dicta of Lord Justice Dyson, as he then was in Halsey and Milton Keynes, 2004 EWCA Civ 576, which said you can't require parties who are unwilling to refer their disputes to mediation because that's an unacceptable obstruction on their right to access the court. So he took the conventional view, and that was appealed to the circuit judge. Judge Harrison granted the council's permission to appeal, but then that judge referred it straight to the Court of Appeal as an important point of principle and practice. And then on the 29th of November of last year, the Lady Chief Justice, the Master of the Rolls, and Burse LJ deftly sidestepped Halsey. We all thought that that was the ratio of Halsey, but the Master of the Roll said, in fact, it was obiter. And those comments made by Lord Justice Dyson, as he then was, saying that truly unwilling parties to mediate couldn't be required to mediate, was obiter. And therefore, the Court of Appeal deftly sidestepped that and said it is permissible in some circumstances for the court to order that the parties attempt to resolve their dispute via NCDR prior to seeking a judicial determination, or the court can stay to allow NCDR to take place. But it must be exercised in a way that doesn't impinge on Article 6 right to a fair hearing within a reasonable time by an independent tribunal, and must be proportionate to achieving the legitimate aim of settling the dispute fairly, quickly, and at reasonable cost. So that's where the civil courts have taken us.
What a case for a DDJ to find, put into a list that no doubt had many other cases in the list also. So poor chap. Thank you, Nick. And Graham, I wonder whether you can help us now, please, about the consultations that took place last year on NCDR and what the MOJ have been doing.
Well, just briefly, the Family Procedure Rule Committee was charged with considering how the rules might encourage early resolution of private family law disputes, short of mandating non-court dispute resolution. And that was seen as being the main priority of the FPRC's work following no-fault divorce, actually. So it was there at the top for quite a while, I think about 2 years, actually, possibly. The Ministry of Justice was tracking at the time a separate consultation concerning the issues associated with mandating non-court dispute resolution. But as it turns out, the government has now decided not to go ahead with mandating mediation for the time being. So it's going to be the new family procedure rules that will immediately impact the family justice system. And when I talk about the best part of 2 years, I think the genesis is when Reese is talking about it. But I can assure you that a lot of intensive work has been done before, during, and after the consultation.
Yeah, and one of the points I know that you are really keen to get across from this conference is the importance of making these rules work, not sidestepping them, because the rules are there to make a change. Am I right? That's a point that you are very keen to get across.
Absolutely. This has to work from day one, and we all have to take it extremely seriously. You are not simply ticking boxes on a form. It requires you to think carefully about using NCDR for all the reasons that have been stated. And that there, you know, we see this as being a sea change. So 29th of April is very much the start of this. And if it isn't taken seriously, there will be consequences. I mean, that's as simple as that.
And it has to be got right from the start, doesn't it? If a system starts to drift, it drifts further. So I think the other point that we were discussing before we started is getting it right from the start. Yep.
Yeah, so I mean the forms will be available to complete online. It's a proper consideration of what you need to do. It's about changing the way of working to be very attuned to this in the same way that we were in terms of making open offers. And so people have got to be ready from day one. It is not just filling in the form, paying lip service, because now you're in court. You can basically just go into litigation mode. You really do need to change the way you're thinking about it.
Yeah, so the word's a sea change, and that's the word that you're getting across.
Yes.
Thank you for making the point. It's really helpful. Thank you, Graham. And Reese, here we go. So what do the rules say?
Right, well, Nick and I would just like to briefly set out the key take-homes from today, which we had up on the slides at the start. First of all, there's been a widening of the definition of non-court dispute resolution. I'm not criticizing mediation. Mediation is a superb out-of-court tool, which is very successful in many circumstances. but it's not necessarily the right tool in all circumstances. And the Part 3 as presently constituted and the definition of non-court dispute resolution has been around a long time. And in the meantime, the sophistication of out-of-court dispute resolution services and the volume of out-of-court dispute resolution services has increased significantly. And so it is that there is a new definition of non-court dispute resolution, which means methods of resolving a dispute other than through a court process, including but not limited to mediation, arbitration, evaluation by a neutral third party, such as a private financial dispute resolution process, and collaborative law. And so now there's a wider definition that everyone's looking at, and there's a change to the MIAM process, which is twin-hatted. First of all, there's a tightening up of the exemptions to MIAMs, which was seen as being relatively easy to swerve around, but also there is now a requirement in a MIAM for all forms of non-court dispute resolution to be discussed and advised about by the MIAM provider. And those of you who watch these things closely will know that around the time that Churchill came out, Resolution announced a campaign about certain aspects of amendment to family law that they were looking for. And one of them was a change to the MIAM process, so that it isn't just provided by mediators, and it provides for a wider range of dispute resolution options. This goes half of the way. MIAMs are deeply embedded in the legislation, and they're with us for some time, I would have thought. But certainly going forwards, it is a requirement on those providers to be fully appraised of all forms of dispute resolution and to be advising people at MIAMs about them. So that's one of the changes. And then the other change I want to mention really is, and tacking back to what Karen was talking about at the start with her Sor Initiative, about making people use Part 3 and encouraging people to write to the other side and say, hey, why don't we get round the table, whether that's in a mediation or an arbitration or something else, but trying to resolve the dispute. And because Part 3 hitherto has not really been effective, and it's a bit of a moribund part of the family procedure rules, the genesis of Karen's idea has found its way into the rules with a new form, which will require people to state openly within 7 days before a first appointment what their position is in respect of non-court dispute resolution. And they need to send that form to the other side so they can say, well, I am willing to engage in this form of dispute resolution, but not that form of dispute resolution, or I'm not prepared to engage in non-court dispute resolution at all, and these are my reasons. Unlike the Ungley order, which was without prejudice save as to costs, this form will be open. And so at the first appointment, the likes of Recorder Allen will be able to run the rule over those reasons and decide whether or not people have good reasons to be in court, or whether in fact they need some encouraging actually to think again about how they're pitching themselves. So new definition, these requirement to exchange views about non-court dispute resolution in advance of the first appointment, tightening of MIAMs and conduct of MIAMs. Nick's got a few other points he wants to add.
Thank you, Rhys. I actually get to refer to the title of this webinar, which I'm very happy about, for those people on the call who wondered why, when we get on to the fresh carrot and the bigger stick. And I'm going to give a shout out to Andrew Day of St Ives Chambers in Birmingham for coming up with that title. So that very grateful to Andrew for that. But yes, it's the carrot and the stick time. The carrot is picking up on the point that Rees made earlier about what Mr. Justice Mostyn had said in Man and Man back in 2014. Well, as you remember, what Rees said, that Mr. Justice Mostyn had said that the court could only adjourn for non-court dispute resolution where the parties agree, and he called for the FPRC to remove that proviso, and that's what happens now with the new 3.41a, which will now provide that where, quote, the timetabling of proceedings allows sufficient time for these steps to be taken, and certainly if you're at first appointment stage, I would have thought that would be satisfied, the court may adjourn proceedings to encourage parties to undertake non-court dispute resolution. In other words, put simply, the agreement of the parties to that course of action is no longer required. Because we in the family sphere are not mandating the actual entry to NCDR, that's where we're still short of the civil practitioners. But so we are mandating, if you like, the adjournment to encourage non-court dispute resolution, but that's as far as the family court is going at the moment. All the points that Graham was making earlier about what might happen if this doesn't work. But so there's that, it's the agreement that is no longer required to adjourn. And then, so that's the carrot and the stick. And I do think this is going to be interesting, is that we all know that we have a starting point of the presumption in financial remedy cases of both parties bearing their own costs, the no order for cost presumption. That's 28.3 sub-rule 5. We know that the court can depart from that presumption if it's appropriate to do so, and that includes the conduct of the parties. That's defined in 28.3(6). And we know in a different context, of course, the courts are increasingly willing to depart from that presumption if parties have not negotiated openly and reasonably when the financial landscape has become clear. But from the 29th of April, there is a new subparagraph in 28.3 sub-rule 7, which lists the factors that the court will take into account when deciding whether to depart from the presumption in financial remedies cases. And the new rule, the new sub-rule, will expressly make a failure without good reason to attend non-court dispute resolution a reason to consider departing from the general starting point that there should be no order for costs, and will be able to look at, of course, the open statement that Rees has said that judges will be encouraged to direct at a first appointment. And we all know how quickly there was an increase in financial remedy practitioners making open offers when we saw the direction of travel of the judgments made by Mr. Justice Peel, Mr. Justice Mostyn, when parties were penalised in costs if they were not negotiating openly and reasonably. I'm reasonably confident that the first time a judge expressly takes into account a failure without good reason to attend non-court dispute resolution as a reason to depart from the no order for costs presumption, that will begin to lead its own sea change, to use Graham's phrase, in the parties' willingness, or practitioners' willingness, to enter NCDR.
Yep. Speaking for myself, I think those provisions are going to make a change, the cost provisions, and I would expect that it won't be long until there is a judgment from a judge that tells us how important a change that is, to bring more pressure on people to engage in NCDR. I don't know if you agree with me, Nick.
Oh, I completely. You know, it wouldn't surprise me if before too long, one of the judges of the family division, you know, they increasingly make freestanding cost judgments.
Sure.
We think of gavel, we think of hotel, and there have been many others, and it would not surprise me that we get a freestanding cost judgment in the foreseeable future, where one party to the litigation has utilised the statement that Reese has talked about, the change to the cost rules that I'm talking about, and that is articulated as a reason to depart from the no order presumption. Of course, it goes hand in glove, of course, with negotiating openly when the financial landscape is clear. So it fits with the direction of travel that the higher courts are handing down their judgments on costs at the present time.
Yeah. And Reese, going back to one of the points, following on the trend of what Graham was saying, I think there's been a tightening up of the exemptions, is there not? Or there's now an expanded definition of domestic abuse to fit in with the definition that is found elsewhere.
Yeah, so the Domestic Abuse Act definition of domestic abuse now reads across, and so references domestic violence are now domestic abuse, and the wider definition that incorporates.
Yeah, but there's also going to be an expectation, isn't there, that there will be an inquiry into why a particular exemption should be claimed, and that inquiry or investigation would take place at the time that the case first hits the court.
Yes.
Yeah, and you mentioned that you discussed that in your article, do you not?
Yeah, I think there may be in practice there may be some difference between money and children cases. Practice varies around the country, but there isn't an embedded culture of immediate gatekeeping of money cases, high value or complex money cases, cases which are asserted to be complex get subject to gatekeeping, but not all cases in the money sphere get looked at immediately like they are in the children case. So it may well be that the rule being run over the reasons why non-court dispute resolution hasn't been attended or a MIAM hasn't been attended will be something that looked at closely at first appointment.
Well, I think it will, because I think that the courts must engage equally in this, and they're going to want to take a much firmer line. I very much hope for myself that is the case. And I know, Graham, you're going to talk in a moment about domestic abuse, and we'll come on to that. But before we do, Karen, I wonder if you can help us about open correspondence and where all this leaves that, please.
Well, the idea of the Sor Initiative and then the Family Solutions Initiative was really to ensure that practitioners were evidencing at a very early stage and throughout the conduct of the matter, proper consideration of NCDR processes, and, as I say, inviting the other side to engage, setting out their rationale, how it would be funded, and the court having visibility of that as and when required. And so what I hope is that this form isn't just a one-step sort of holding a light to what's going on, but perhaps, and you know, for those of us on the panel who are also judges, whether we will expect the court to see the form, but also get to see some of the correspondence that passes between lawyers, to put it into the fullest context so that people are properly considering who's available, what is the cost. And I think, and perhaps this is a consideration if a matter's moving to a final hearing, where unfortunately we hear so many cases are being pulled through lack of judges, that some way out from a final hearing, people start to, and I see James Perry's put a helpful question in the Q&A, to consider the alternative of arbitration. So some way out, who's available, who might be available, and what might the costs be. If one party is saying, I'll meet the reasonable costs, you choose the arbitrator, whether there's more fulsome open correspondence is going to be helpful to the court, particularly in terms of the management of the case, but in respect of this new cost rule.
Yeah, arbitration has surely got to develop further. It makes such obvious sense, doesn't it? And how many people have seen their cases shunted out of the list when they're after a lot of cost expenditure because a public law case has suddenly come into the list. And that really can't continue, in my view. And that is an arbitration is an obvious way of taking cases away from the court list, and also allowing people to choose the arbitrator, the judge who's going to decide the case, and getting the right level of judge, the right person to judge the case. So thanks for that. I wonder whether we could now go to you, Graham, to speak about domestic abuse and where that fits in with this.
Well, thank you, Stephen. So the most notable change has been in the language from domestic violence to domestic abuse, as well as the connection between the parties changing from being someone who is in a family relationship to being someone who is personally connected. So abusive behaviour, the definition is widened. So it includes physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, and psychological, emotional, and other abuse. So in addition to the detailed provisions which already existed for MIAM exemptions, there are some additional ones, including a letter provided by an appropriate independent health professional to confirm they are providing support to a party who has been subject to domestic or sexual violence. The examination by the health professional can now also be done by telephone or by video conferencing, as well as in person.
Okay. Thank you. Now, there are a lot of questions on the Q&A, Reese, that I can see there are 17. I'm going to ask Martin if you can help us with one other question, but Reese, whilst Martin's dealing with that, I think you're triaging the questions. And so for those who've asked questions, we are going to come on to those. And I think we need to leave slightly more than the 10 minutes we originally planned, if that's okay with you, Reese, to cover that. So, Martin, help us about the rules, how they differ between money and children, please.
Sure. Well, Reese has touched on it, I think, a moment ago, which is in relation to the extent to which gatekeeping plays a role in children cases, more so than it does in financial dispute matters. There will, I think, be an expectation that gatekeeping will be undertaken in a much more robust manner with the change in the rules. So there will be consideration given to whether or not parties have attempted any NCDR before. And if not, I think we can expect there would be effectively the matter wouldn't be listed and an order would go out from the court saying you need to go and try this before you even get across the threshold of a hearing. Even if you do get to that first hearing, I'd expect there to be greater consideration at the level of that first hearing, the FHDRA of NCDR as well. So I think we can expect that. That feeds into where we are in terms of children cases at the moment. We know that there is a portal which is being utilised in Swansea, I think, at the moment in a pilot form. That's the only part of the country where it's being used. I don't know exactly how that's working, but there will be a need for those forms to be provided to the court so that courts can determine the reasonableness or otherwise of people's willingness or unwillingness to engage in NCDR. And then finally, I suppose we come to the issue of cost, because if there is a presumption in money cases that costs, there will be no order for cost. I think we can say that much more so in children cases. And so we may, again, going back to a point I think you made, Stephen, we'll wait for that first judgment where somebody is considered not to have engaged in something unreasonably, utilising the common law way in which that has developed in children cases, to determine whether or not cost orders should be made. So I don't foresee it'll necessarily move as quickly because it's not supported in the same way by the change in the rules that it is in money cases. But certainly the basis is there for those factors to be taken into account.
Yes, I think one of the problems in private law cases where you have litigants in person is they simply don't know how to go about finding somebody with whom they can engage in NCDR, and therefore the prompt that comes from the court through adjourning to encourage NCDR would be a very useful one indeed. Where the funding will come from for that NCDR is something that will no doubt be of concern to many solicitors. Okay, thank you very much. Thanks for that, Martin. And Rhys, you've been triaging the questions, and we've got lots of them. So
can I say they're good questions. I'm almost overwhelmed. I'm sorry we don't have another hour to deal with all of them. We're only going to be able to touch on some of them. But can I thank also Karen Barham, who's been putting some links up in the chat, and I can see that they're directed at everyone. So there's some useful additional materials there, and please cross-refer to them. One of her links is to some superb blogs which have been provided by Caroline Bowden on the Anthony Gold website. I commend those. It's very, very helpful documents. And to borrow a phrase from Steve Wright, I'd like to give a shout out to Caroline Bowden for the tremendous work that she did on the Family Procedure Rule Committee Working Party, looking at exemptions to MIAMs and the tightening up. And she did a tremendous amount of work. And her experience and insight was absolutely invaluable. So I'm going to turn to her first of all with one of her questions, given that background. And she says, does the Family Procedure Rule Committee plan to have any ongoing monitoring role to see how amendments are working out in practice? It's a good question, which I'm afraid I don't know the answer to. And being on the family, Graham's putting his
Graham, I think, can
go on then.
I think I've been on the FPRC as long as you, Rhys, but from my experience of how these working groups last, they tend to hang around while the rules are being implemented, and it will be, I think that the greatest likelihood it will be reviewed by the FPRC as it's being implemented, because it's been the top priority of the FPRC for 1 or 2 years. So I can't say categorically that it's a yes, but I think it's extremely likely, because I know that the members of the FPRC, and this goes all the way up to the president, take this initiative extremely seriously, and they want to see it work, which really mirrors what I said earlier in my discussion with Stephen. It has to work from day one.
A question in from one Michael Horton, King's Counsel, and I think we'll direct this at Nick. Does Churchill apply in family cases so that the family court can adjourn in order for parties to attend mediation?
I think the answer to that is no, in the sense that that's that point about mandation. In other words, as Churchill basically says, you can be mandated to enter a form of NCDR, whereas where we are, so long as it all works, is you can now be mandated to be encouraged to enter NCDR. So that's the difference. That's where we've stopped short of the actual mandation. So our new 3.41a takes out the agreement to adjourn. The court can require the adjournment, but the adjournment is to encourage parties to undertake non-court dispute resolution rather than they must undertake, which is effectively where we are in the civil sphere. But I can see Karen's got her hand up.
Karen got a finger up.
Yeah, I have. Do I understand the rules correctly that the court can mandate a party to attend a MIAM, including respondents? That, I think, is my understanding.
Yeah, so there's a difference between MIAM and then actually attending at full-blooded, as it were,
proper
dispute resolution. They're two different creatures.
They are two different creatures, but I think what's and which I didn't know until I was on the MOJ working group last year, is that effectively there is no gatekeeping at the point of issuing a court application to ensure MIAM compliance. And I know, Reece, we were sitting there pleading, I think you'd use the expression, use a sprat to catch a mackerel, of redeploying some resources to the point at the point of entry and issuing a court application, which I understand will now happen. So much tighter gatekeeping. But I do understand the new rules does enable the court to compel a person to attend a MIAM, including a respondent. And so I suppose for practitioners here, look at Caroline's excellent piece on the few remaining MIAM exemptions. Ensure not only your applicant has attended a MIAM, if you're advising a respondent, ensure they attend a MIAM as well, because the court can compel them to do so.
That's a very important point, isn't it, Karen? Because up to this point, the system has shied away from requiring both parties to attend a MIAM. And on what you're saying, the rules now can mean that a respondent, as well as an applicant, may be compelled to attend a MIAM.
Absolutely. And certainly since the standards board of the FMC in the October 22 latest standards require all forms of NCDR to be explained. And a MIAM isn't just a simple, is mediation appropriate? It's a requirement to explain all forms of NCDR. It's a requirement to give potential litigants a heads up in terms of what the court landscape looks like, including costs and delay. It's an opportunity to signpost to other support services, domestic abuse, etc. So the MIAM, it has a number of roles, incredibly important, shouldn't take less than 45 minutes to 1 hour.
Just picking up on some other questions, Sarah Unsworth asks, I'm interested in the tightening of MIAM exemptions and what the detail of that is. Thank you. If you go to Caroline Bowden's blogs, that's all set out helpfully there. A comment made by Heidi Burrows, an observation as a pupil barrister who's just completed the bar course, there was close to no element of non-court dispute resolution in any part of the bar course or pupil advocacy course. A tiny bit of the civil litigation course acknowledged its existence. That was it. Seems like a missed opportunity to me. Well, yes, I agree with that entirely. And I think that's something which we all need to think about carefully. Turning then to James Pirry, he asks, with the new structure of the rules, might there be circumstances where a costs order is made because somebody refuses to attend or engage in a fixed fee arbitration? Nick, what do you think of that?
Why have you thrown that question at me? I'm going to dodge that question only to say the rule is broadly drawn. It expressly includes the phrase without good reason. Those words are no doubt there for a reason. That will be case dependent on the parties to the case, the nature of the litigation, what was offered and why there was the refusal. So I don't think it's going to be a one size fits all. It's a well drafted rule. It gives the court the power to do what the court thinks is right on the facts of the facts of the case that is in front of it. But I think beyond that, it's difficult to speculate as to what a court may do in any particular case.
I think what I'd chip in with, crystal ball gazing and no more than that, is that because the new definition is so wide of non-court dispute resolution, and it's coupled with this stick of a threat of costs, that those parties who don't engage in non-court dispute resolution saying, well, I want my court hearing because it suits them to have the delay, I think they may find themselves having a slightly rougher time than hitherto they've had.
Reece, can I just pick up one of Sarah Smith's questions,
Sure.
if you can, just very, very quickly, because she asks amongst her questions, will there be training for the judiciary, which is obviously very important for what we've all been saying. The answer to that is the Judicial College, which runs courses for everyone who sits in the Financial Remedies Court, has included papers on this for judges who are going to sit in the Financial Remedies Court. It's part of the background reading, and whoever lectures on first appointments at the induction courses for judges who want to sit in the Financial Remedies Court will be told about these new rules, will be told about these new powers. So I think we can expect when we go to our first appointments that judges will know to ask the relevant questions and will know what their new powers are.
I hope so. Yeah. Can I say we've got less than 2 minutes to go, but Karen, thanks, Nick.
Can I pick up a theme that is coming through? When will the new form be available, and do we think we will have our forms in place in good order? And perhaps Rhys and Graham that sit on the rule committee can confirm. But there's a question there from Tracy O'Dwyer that the new rules will bite on the 29th of April, irrespective of when the Form A was issued. Can we just understand that timeline, that
Yes.
we will be talking about new rules on the stroke of midnight, you're then into new rules territory?
Yes, and the forms are in the process of being worked on. So the different iterations of the draft are bouncing around at the minute. But certainly they will see the light of day shortly.
Okay, well, thank you to everyone. It's now a minute until the webinar closes. Can I thank our speakers? I've had the easy job. They've done the hard work of preparing answers to the questions. So I'm extremely grateful to each one of the panelists for the work that you've done. And thank you to Hannah for helping us by hosting this webinar. We hope you found it of assistance to you. And we do hope that this is going to show what Graham has called a sea change. Rhys, are there any other articles that you think are coming up in the FRJ, for instance, that you'd like to mention?
So there's an article prepared by Nick, Andrew Day and myself, which will be in the spring Financial Remedies Journal, dealing with this from a money perspective. Caroline Bowden, I think, is also having a wider article, perhaps with more emphasis on children, published in the forthcoming family law. So I don't know whether that will be February or March or April, but certainly in the very near future, she will have an article in family law, and I'd commend her blogs in the meantime.
Well, our thanks to Caroline as well. Thank you very much indeed, everybody, for joining this webinar. Hope you've enjoyed it, and we wish you well. Good afternoon.